Hello, thank you for joining us today. My name is Amy Hennen. I am the Director of Advocacy and Financial Stabilization at the Maryland Volunteer Lawyer Service. Today we're going to be talking about financial stability information, especially in these unstable times. Couple of initial housekeeping issues or matters. If you are looking for both the presentation and our resource companion guide, both of those are available in the handout section of the GoToWebinar. And so if you just go to the handouts drop down, you should be able to get them. If you're viewing this later, you should be able to see both of those resources readily available. If you have questions as we go along, if you want to pop those into the questions box, we'll be monitoring the questions throughout, and we'll answer them as we go. And with that, my colleague Asia is going to start it off, so I'm going to turn it over to her to introduce herself and get us going here.
So, hi, I'm Asia Mallory. I'm the consumer staff attorney at the Maryland Volunteer Lawyer Service, and I'll be speaking with you all for the first half of the presentation. So, next slide, please, Amy.
Yep.
So today's is just to inform professionals about the financial issues facing vulnerable adults and some possible legal issues. Important to note is that this information in today's presentation is not legal advice. Always consult an attorney for legal advice for any particular situation. Next slide, please. The topics we're going to cover today is going to be twofold. One, the first section will be preventing financial problems, and then the second section will be dealing with financial issues. We're going to try to give you information on getting and staying organized, co-signing for a loan, and from undue influence, and also applying for Medicaid. So next, I think. So our first topic would be bills, organizing and managing your bills. The I would suggest is when you have a client, establish how much money they owe and to whom they owe this money to, and prioritize their bills. Utilities and food are the priorities. If your client is unable to make all of their payments, definitely seek help right away. We can call 211. You can find a licensed professional, a nonprofit credit counseling agency like CCCSMD, which is Consumer Credit Counseling Services of America. If your client or whomever you're helping is agreeing to a payment plan, make sure that plan is in writing, the payments are affordable. Keep all records of the payments they're making. So it's keeping copies of checks or any money orders they may have, and also just continue to keep records of the payment and the debt balance. Next slide, please. So our next topic is co-signing. What is co-signing? Co-signing is taking on the responsibility to pay back the loan if the borrower pay the debt. Why would someone need a co-signer? Having a co-signer is very helpful to the borrower or a lender to lend to them unless they have a co-signer, and it may reduce their interest rates. Co-signing has very little benefits and also a lot of risk. So we definitely ask that you be careful when you co-sign on to something. Next slide. So a few of the risks of the co-sign is that a co-signer is liable for the entire debt balance if the borrower doesn't pay. So we're saying yes as a friend, spouse, child, or whoever may ask you to co-sign. Before you say yes, please consider these risks. Again, you will be liable if the borrower doesn't make any payments. The lender can sue you for the money before suing the borrower, and they usually you have a better credit score and are more likely to pay. This will definitely negatively affect your credit history. The lender can also interest, late fees, and collection fees. The lender may be able to garnish your wages. Sometimes taking on too much credit will make them to lend to you. So it's very important that you really, really research what you're getting into. It is also difficult to get out of a co-signed loan. For example, if you co-signed for your spouse, a divorce will not free you from the debt. If you settle with the lender, the IRS will consider the forgiven amounts as debt forgiveness income, which can also be taxed. So co-signing can damage relationships and can also be a financial burden for some people. Next slide. So if you are a co-signer, what you can do is, one, understand why the person is borrowing the money. Like, just know why they need this money. Know what your legal and financial obligations are going to be, including your payments and the interest rate and anything else that comes along. Set aside money to repay the loan just in case the borrower stops payments. Maintain open and constant communication with the borrower. Once the lender contacts you, your credit history has already been damaged. Have an account and monitor it to ensure payments are being made on time. Last but not least, but definitely sign an agreement with the borrower that they will pay you back if they go into default. So these are just some things that as a co-signer you should do just to keep yourself on the safe side. So the next thing we're going to talk about is undue influence. What is undue influence? It usually occurs when a person pushes someone else to act against his or her best interests. The victims are often vulnerable or marginalized in some way, so older adults and adults are susceptible to harm. The influencer may be a loved one or a caretaker. It's often someone in which the person holds a lot of respect, esteem to. Um, Definitely watch for warning signs to help prevent undue influence. How we would prevent undue influence is, one, communicate openly about potential difficult topics. Have a written agreement, keep a paper trail, use cash, document gifts, or in some instances, just avoid them altogether. No joint bank accounts when helping with estate planning. Don't just use any type of estate planning forms. Do not isolate the care receiver relationships. Again, we tell you that this is not legal advice. Please consult an attorney about your particular situation. We're just giving you tips to help prevent undue influence for vulnerable people or older adults or whoever may be in trouble. So Medicaid. So Medicaid is interesting because applying for Medicaid is helpful for people who are experiencing financial hardships or low-income individuals. It's different from Medicare. Medicare for people who are over 65, over the age of 65. But Medicaid is probably one of the better option than Medicare. You can apply in two ways. You can go online at the Maryland or you can apply in person at DHS's any one of their local departments. You should determine if you are eligible for Medicaid. Medicaid in Maryland, Medicaid coverage is retroactive to hospital bills from the prior 3 months, as long as you would have been eligible for that time. So that is information about Medicaid. So now we're going to move on to dealing with financial issues. The first financial issue that we will come up with, that we usually deal with, are debt collection. debt collectors have rules and regulations that they have to. I'm just going to do a summary of some of the debt collector rules and regulations, because this can be a lot to talk about. This is so debt collector cannot come at inconvenient times or places unless the debtor agrees to it. They cannot harass or abuse anyone over the debt. They can't lie by claiming that they are a government agency. They cannot report incorrect information or collect any additional interest or fees unless the contract or state law allows it, and they cannot disclose information about the debt to third parties without the debtor's consent. It's important to note that a debt may be a scammer if they are saying they are sending the sheriff out to arrest the debtor, or they're requesting payments in gift cards or similar methods. But if the debt collector is being really harassing, they definitely could be a scammer. So watch out for that. Some requirement collector is they have to say they are a debt collector. If they do not tell you they are a debt collector, they could again, they need to provide written verification of the debt, just to prove that you owe the debt or that the debt they're claiming to be yours. You can also, if you request that the debt collector stops contacting you in writing, they must honor it to apply payments as directed by the debtor. But these requirements go more into depth, so that would be we would have to talk about that. Contact an attorney at MVLS. So if you are being contacted by a debt collector, that would be a great time to contact an attorney at MVLS for help. So debt collection and lawsuits. Just a quick summary that if you receive a lawsuit about a debt collection, again, contact an attorney right away to get their advice, because these complaints can be difficult to navigate. Definitely do not ignore the court papers coming to you or the notices or any of the deadlines, because you could very well be ruled, the court may very well rule against you in court or in a trial. So some quick legal defenses to a debt collection case. Again, this is not legal advice, but just definitely contact an attorney if a creditor is coming after you or a client. Some legal defense, you do not owe the money. You do not owe the money in question. The debtor has agreed to the creditor's payment plan. The debtor did not receive or properly receive the important court documents. The debt is too old. The debt belongs to someone else, such as a family member or a spouse or a friend. The debt was discharged in bankruptcy. The suit was filed in the wrong court, and the alleged of identity theft, and so they never incurred the debt. But in order to prove these defenses, the court will require documents for any of these defenses you may have. So definitely keep records. So a lawsuit for would include pretrial discovery about income and assets. If fails to respond to interrogatories or to appear for oral examinations, the court may issue a body attachment like an arrest warrant. If when you're going to court, definitely show up early. You can request a remote hearing. In trial, the creditor is required to present evidence showing that the debt is lawful, and the debtor is allowed to present any defenses mentioned earlier. There are some related motions as far as the debt collection and lawsuits and all of that by that nature. Motion for release of property from lien garnishment or to exempt property from the execution, but these things would have out with an attorney. So the next thing is judgments. We'll let Amy talk about judgments.
You did.
Sure, thank you, Asia. All right, so if often we encounter folks when they already have a judgment in place, and so then it becomes a bit more of trying to figure out, you know, kind of what's going on, what can we do, how can we help them. And so just a couple basic things. Judgment is just a decision by the court saying that the person owes them money, and these are some other definitions, and just in case you're looking for a way to kind of help explain to folks that you're working with, or you know, kind of what it really means. People often get scared about judgments, nervous, you know, about what they mean, and so just kind of having some information can be really helpful. There are some timing things about when a judgment gets entered, and kind of some action steps that can potentially be taken within the first 30 days, and that's a great time to, if something went wrong or something was off or what have you, to take action to either file an appeal or request to alter or amend the judgment. It is possible to potentially do those sorts of things maybe after that 30 days has expired, but there may be situations where it's not possible. And unfortunately, that's one of the things about dealing with lawyers. It's like, oh, maybe is an or sometimes it's kind of an often answer. But again, important to get legal advice about the particular situation. So if a debtor is not able to pay, if somebody who's got a judgment against them is not able to pay, and they could potentially be subject to garnishment, and that can include wages and bank accounts. There's a tricky piece about where if somebody actually is maybe a 1099 worker rather than a considered employee, there's a difference in the amount that a garnishment could potentially take. It's the difference between usually 25% and all of it. And so it's important to kind of think about kind of, you know, these various things and kind of talk through what your options are. A seizure of real estate and personal property is theoretically possible and way less likely, and so is not much of a major concern when we're talking about these sorts of judgments, unless, well, the real estate, unless we're talking about like an HOA, which are really aggressive, homeowners association or a condo association. So the creditor can potentially request that somebody come to court and provide income or financial statements so that they can figure out how the creditor can figure out how they're going to collect on these, and providing that income or demonstrating these financial statements is going to allow them to collect, but the court will order this, and so if the person doesn't, they could be in contempt of court. However, there are a number of things that are exempt from collection, that especially for regular, traditional kind of just consumer credit, like a credit card or an old apartment that somebody moved out of, medical debt, car loans, things like that. And the important thing about that cash up to $6,000, that's not an automatic exemption. That is an exemption that the debtor has to claim for themselves. The person who has the judgment against them has to claim for themselves. And so again, so there's a form to do it, except it's really helpful to get some advice from an attorney again, with that particular situation. If you're working with somebody that's facing a judgment, again, get them over to MVLS, connect them with us. And then we've got some other things on here that are all exempt. I think an important one is retirement accounts, because that actually is unlimited. And so if somebody has got you know, a little bit of money set aside or something like that, they don't necessarily have to turn it over to a debt collector, and you know, shouldn't, arguably. But if the debtor is going to potentially is going to be looking at if this person with the judgment against them has got is going to potentially be facing a garnishment, it can in fact be better to set up a payment plan in advance, so that they're making perhaps a monthly payment to avoid any sort of garnishment or seizure of any bank accounts. If somebody is needing to get is got a bank account garnishment right now and they need help just immediately, they can also call the self-help center, which can walk people through how to fill out the form. Again, it actually can be helpful to get some help from an attorney when doing these negotiations, because sometimes attorneys can actually get lower payment plans that people can afford more, because obviously the important thing is not so much, the important thing should be less what the amount of the payment is, but more what the person can afford to pay, so that they don't actually miss a payment. And obviously things happen, but when they miss a payment, the creditor can then start to act on seizing some of the property or filing for that garnishment. So thinking about garnishments, there is protected income and there's not protected income. Protected stuff is absolutely public benefits, Social Security, and again, those retirement benefits. But traditional wages are not protected. They can be garnished up to 25%. And then the other thing to note is that if it's a payment for somebody who's doing contract work rather than somebody who is an employee of a business, if a creditor finds that, they could potentially garnish the whole thing, which would be a lot. I just want to mention that we're talking here about sort of traditional consumer debts, and that is not going to necessarily include child support, delinquent taxes, or federal student loans, because those are things that actually could potentially garnish things like Social Security. And student loans in particular, they can garnish up to 15% of Social Security benefits. It's sort of a callback to what Asia was talking about before about co-signing. We definitely see some of our older adult clients that have co-signed for maybe a child or grandchild to go to school, and they have co-signed for those federal student loans, and then the grandparent is potentially facing garnishment of their Social Security when those loans don't get repaid. And so that's why it can be really important to kind of keep on top of, what's being paid, what's not being paid, and figure out, are there options, in the event that it's not being paid. So bank garnishments, they put a freeze on the account, and the owner is not allowed to access it. If you are potentially facing a bank garnishment, the tip at the bottom is actually really useful. Like if you can direct your deposits to another institution as quickly as possible, that would actually maybe help you keep some of your money, because anything that gets deposited in that fund could be frozen. I think that the other sort of important thing about this is that although we were talking about how there's the ability to exempt up to $6,000, if you don't, even if you file that, let's say that you've got under $6,000 in your bank account, and if you file to protect it, your account could still be frozen for several weeks while the court, if the court is going to potentially enter a hearing, if there's something that is potentially going to be contested, and so that can actually put that money on hold. And we know that many of the people that we work with, and a lot of people can't necessarily afford to not have access to their income for several weeks. The money that's in their bank account, it can result in just an absolute terrible spiral of, not being able to pay your rent or utility bills or be able to put food on your table. It's obviously a really kind of critical point. And again, important to kind of get some help from an attorney to see if there's anything that could be done to either help it unfreeze quicker or things like that. The other thing is just quickly about joint bank accounts, and this kind of ties into what Asia was talking about before about the importance of not having not having, so if you're trying to do sort of help somebody with estate planning, or somebody just wants to make sure that you have access to their funds, putting somebody else's name on your bank account can mean that any judgment against them could potentially mean a seizure of your bank account. And that is, I mean, really is just a huge bummer, obviously, but also, if you have to file to protect it, you can do that. You can say that every cent in here is actually my money, is not the money of the other person. But again, we're going to be talking about that sort of 6 month or usually about a 6-week period where the funds are going to be frozen, and that can be just really detrimental. There is a sort of separate issue that has to do with if it's a bank account, a joint bank account of a husband and wife, and that might be protected if the judgment is only against the husband, but that's not always 100%, is not always clear. The one other thing I'll say about bank garnishments is that if you're receiving only Social Security and you've got under 2 months worth of Social Security in your account, let's say that you get $1,000 a month from Social Security and you've got less than $2,000 in your account. That means that there's actually a federal law that protects the less than 2 months worth of Social Security deposits in your bank account, as long as we're only talking about Social Security in the account. So that can actually be really, really great if somebody is only on Social Security. That means they cannot get a garnishment against their actual Social Security income, and also that once that money hits their bank account, it's also protected. So just a useful tip. All right, let's talk about hospital bills. This image is a wild one. Hospital bills are one of the things that we always talk to people about, kind of prioritizing pretty much last, because there are a lot of reasons why you want to sort of put them kind of lower on the totem pole in terms of your kind of debt. And often they don't wind up on your they don't wind up on a credit report, and there are a variety of important ways to potentially help reduce them. There's a bunch of financial assistance that's available. In October 2020, a new bill that was passed this year went into effect and actually expanded financial assistance programs that hospitals are required to offer. So this greatly expanded the number of people that are eligible for this assistance. And the other thing is that hospitals will often take very, very low payments, $25 a month or something like that, and that can actually mean that you have more income to potentially devote to other issues that you've got going on. And then, of course, really critical, tying into what Asia mentioned before, getting people onto Medicaid when they've got a significant hospital bill. If we're talking about, especially about a hospital bill that was incurred within the last 3 months, that could be entirely covered. So it's a great choice. So a little bit more about the financial assistance programs. All but one hospital in Maryland are nonprofit hospitals, and I think the one that's not the only one that's not a nonprofit hospital, I think that one's in Montgomery County, if I remember. But they're all required to have these programs, so things that might not, when it's talking about things that might not be covered, things like plastic surgery that's not medically necessary would probably not be covered, but many required services for health, etc., that are needed are going to be covered. But it's important to apply as soon as possible, and then there's going to be a bunch of financial information that is going to need to be provided to that hospital in order to apply. And so they could ask for things like information about your budget, and they could want to see your tax returns. But the way you start the process is calling the hospital billing office. If for some reason you're working with somebody who has applied for assistance and the hospital has denied that financial assistance. There are definitely appeals. The Maryland Office of the Attorney General has a specific office that has a specific sub-office that deals with issues with medical billing, and so that's a second avenue for getting some assistance. And then if it doesn't work out, again, we're talking about really low payment, just ask for the lowest payment plan possible, kind of depending on the amount of the bill. This could be $15, $20, $25, which is, not nothing, but more affordable for most people. And again, there are a lot of other things that are going to just be a lot more important in terms of, making sure that you have stable housing, and making sure that the client has keeps their utilities on, is able to put food on their table. And again, medical bills are subject to the same sort of garnishment and judgment that we were issues that we were talking about before, but so I wouldn't say ignore them entirely, but there are obviously some additional options that are available for folks. And even if somebody is getting to that kind of collection phase, it can still be a good idea to actually apply for Medicaid and or apply for that financial assistance if they don't qualify, because they can still maybe get the total bill reduced, even if they are further down the road. All right, so let's move into talking a little bit about bankruptcy. Just as kind of a quick primer, there are several different chapters, several different types of bankruptcy. Chapter 7 is often referred to as the liquidation bankruptcy, and Chapter 13 is often referred to as the repayment bankruptcy. These are the two kinds of bankruptcy that most normal individuals are going to potentially be applying for. Or seeking help through. And MVLS helps folks seek bankruptcy help. There are downsides to applying to seeking bankruptcy help. It's expensive. That says $335, and I forgot that just in December 1, the filing fee is now $338. It went up by $3. But it can be a lengthy process. It can be annoying. It's something that you absolutely need to do with the help of an attorney. There are other kinds of people out there in this world that help people file for bankruptcy, but they can't give you legal advice about what you can protect and what you can't protect in bankruptcy. And I've seen some really negative things happen when people use these sort of alternative options. And so I always just say, if we're talking about a low-income person, they should go through a program like MVLS. And if they're over that income, they should figure out a way to set some of that money aside so that they can get out of bankruptcy. So we flagged here that the bankruptcy bypass may be a good option for some people when we're talking about kind of why bankruptcy is not always the best choice, but it's not a best option for everyone. It's the best option, especially for folks that are collection proof, people that have only Social Security as their income or are otherwise exceptionally low income. They actually may be collection proof. The creditor may not be able to get anything from them, and it's possible. We have this bankruptcy bypass program where we will send letters to creditors to tell them to leave the person alone and that they're not going to get anything. And that's after doing a sort of thorough review of all of the all of the kind of various issues that might come up if they were to sort of pursue this bankruptcy bypass process. So somebody who's collection proof generally means that they've got assets under $6,000, assets that are exemptable, and that they've got income that is not going to be directly garnishable. And so that often is going to mean somebody who's receiving Social Security, but that also could be veterans benefits. That could be their only income is their retirement account. It could be that there are a couple of kinds of pensions, et cetera, and of course TCA. So somebody might not always be collection proof, and so just it's important to, you know, if something changes, it could potentially impact whether somebody is collection proof or not. You know, somebody starts working again or something like that. All right. Right. Again, these are the various kinds of incomes that are generally protected. And again, there's that note there about how when we're talking about income that's protected, we're not talking about we're not talking about non-consumer debts, and that's or debts that include child support, federal student loans, etc. So I'm going to just for fun. Going to talk a little bit about reverse mortgages. And these are reverse mortgages are often looked to as a way for somebody that is experiencing a financial hardship, is over the age of 62, and owns a home. This is potentially a way to help them get access to some of the equity in their home, and maybe help kind of help them age in place, help keep them in their communities. But it's not, you know, there are some downsides. It's different than a regular mortgage because there's never a payment that gets made to the lender, but the amount that's owed increases over time because there's an interest rate that's attached to the money that's given to the homeowner. So if the homeowner passes away, or sells the home or moves out, and that could include moving into, say, a nursing facility, then the loan potentially has to be repaid, and if not repaid, then they would foreclose on the home. The borrower has to go through a reverse mortgage counseling, and there are certified reverse mortgage counselors from the various from a variety of counseling agencies. Excuse me. But again, there are some pitfalls that we're talking about here. So the borrower is generally going to be responsible for property taxes and insurance and other normal bills. And we've seen this come up in a number of ways with clients that we've had where, especially if maybe one spouse was responsible for taking care of the property taxes and insurance, and maybe that person passes away, and then the other spouse has to take over. We often see that there's sort of a gap that occurs in terms of getting those property taxes paid. Sometimes there is money that's actually set aside for property taxes, and this is actually separately tricky because the person doesn't know or doesn't remember, or the reverse mortgage company is just paying for those property taxes. So the person isn't applying for the homeowner's property tax credit in Maryland, which is obviously reduces the amount that the either reverse mortgage company is laying out, and thus the amount that the person potentially owes in the end. Obviously the amount kind of continues to grow. That's a sort of another downside. But I think one of the biggest downsides of reverse mortgages is actually just that it really prevents a family from being able to build in kind of family wealth, be able to pass a house, which may be their only asset, at least for our clients it is, onto the next generation, and ensure that that next generation is going to have access to good, stable housing. And so it can really kind of reverse mortgages, you know, can be useful if it's a really necessary, critical sort of thing, but can also, the obvious downside is the impact on community and family. And so it's just in general, if someone is thinking about taking out a reverse mortgage, it may be a good time to have a conversation with family about kind of what's going on. So just a couple of things to note. If there are plenty of situations where maybe one spouse reaches age 62 first, and so the couple decides that person's going to apply for the reverse mortgage, and we've actually seen it where basically a deed transfer occurs between the spouses, where one spouse transfers the home to the other solely so that the reverse mortgage can be taken out. That's the other spouse who was younger is protected in the event that the older spouse passes away first. But obviously, property taxes and insurance need to continue to be paid. If somebody does take out a reverse mortgage, there is a 3-day cancellation. That would obviously have to be done very quickly after signing up. The other thing is that we definitely see scammers kind of operating in this sort of space where they trick people into taking out lump sum and kind of giving it to folks for an investment scheme. And we see people who meet these scammers because they've come door to door or because they are in their same church. And so these scammers can really come from anywhere. It's just important to kind of know that they exist. All right. Finally, about reverse mortgages. Nope, talked about that. Finally, we have a resource list that is both, it's in the handout section of GoToWebinar, and we'll have this posted along with this presentation when it gets uploaded later. And so there's a bunch of really helpful information in there about kind of where to access some additional information, maybe who some services are to potentially call. I hope that you have found this presentation helpful especially if you're going to be working with clients that are going to need this information. And so I want to thank you so much for joining us. Both Asia and I just appreciate the opportunity to chat with you. I don't see any questions that have come up along the way. Obviously, there's our contact information isn't in here, but I'm available at Hennen, AHENNEN at MVLSlaw.org, and Asia is at MALLORY at MVLSlaw.org. Reach out to us. We're happy to talk with you about kind of whatever issues it is that you're seeing, and we look forward to supporting you. So with that, I think we will sign off, and we just thank you so much for joining our presentation.